May it please the court. Rebuttal time?
Yes.
5 minutes, please, Your Honor. Your Honors, this case is all about the significance of going to trial and losing and stipulating to the stakes. The simplest.
Same basic issue, the same basic problem.
That's correct, Your Honor. The case was tried twice on the same issue on the same parties. Exactly. It shouldn't be, because res judicata should have precluded it. And that's what we sought on summary judgment to preclude from happening. The simplest path to reversal is the application of this court's Hardcastle decision. That's controlling here. That sets out what I'm calling the Rubicon of trial rule. Okay? When you go to trial on a claim and you lose, the resulting judgment is on the merits because you went to trial. That's what transforms it to a merits judgment. And after that, it triggers res judicata. This court directly addressed that question in Hardcastle. And again, it does not matter that it was a condition precedent defense that was the result that resulted in the first trial's judgment for the defense. That's exactly Hardcastle.
With the guarantee is based on, hey, I'm signing this in the event the borrowers default, correct?
Correct.
I'm not liable until they default. They default. First action on their default. Final judgment against them. Default's over. Mortgage is done. There's no continuing obligation by the borrowers, correct?
Correct.
Okay, so the stipulation says, Judge, we're going to litigate whether there was a written demand to damages. We're going to litigate standing. We're going to litigate damages. Also says that should ReadyCap prevail, ReadyCap would have a final judgment against borrowers and damages, correct?
Correct.
For the note, any interest, deficiencies, fees, whatever, right?
Yeah, and I will just say there was already a foreclosure judgment entered at the time the stipulation was entered. So there'd be a second judgment.
There's a final judgment against the borrowers.
Correct.
So there's no continuing obligation. So I think what your opponent's argument is there was some sort of new default since they sent a letter to your client. She said, no.
Correct.
Tell me about that.
That's the Singleton Project. That doesn't apply here because this isn't a mortgage claim. This is not a claim on the mortgage. Now, everything you just said is correct, Your Honor, except for the fact that the claim brought against Dr. Daniels in both cases is a claim for breach of contract, and not an installment contract, Your Honor. A claim for breach of a guarantee that has just one obligation: pay all amounts due under the note. No, there's no acceleration language. There's no installment language. Pay all amounts due under the note on written demand. So, and for guidance, Your Honor, this court's already addressed what would happen if someone filed a premature claim and proceeded to trial and lost. That's the Shuck case. And it was in a different context than Hardcastle, to the extent there's any distinction about the specific claim in Hardcastle. So Shuck already tells us, even if you are going to trial on a premature claim, one that hasn't accrued, one that hasn't arisen, one that there hasn't been a demand given. Hardcastle is a false arrest case. Shuck is a trust dispute. It has to do with I believe there's a marital agreement involved, and it was a premature claim because a contingent event had not happened.
Is there any difference between a statutory contingent condition precedent under 76828 for Hardcastle versus your case where it is a condition precedent and Judge found it was unambiguous? You got to notify Daniels before you sue her. Give her an opportunity to pay or not.
No legal difference, Your Honor. I would argue there's absolutely no legal difference. They serve the same purpose. It's notice before you're subject to litigation. Now, the notion that this was somehow a different event of default because there was a letter that was given, that was just a correction of a backfired trial strategy in the first case. That's what's triggering this court's decision in Schmidt, which again, res judicata and should.
There was an effort to comply with the precondition for the second trial.
That's correct. That was the missing fact in the first trial. But why does res judicata apply? Because you're litigating the same exact facts. That you just didn't have evidence of your compliance with the condition in the first trial, but it's the same condition.
So you're saying the first trial is lost on the merits, correct?
I am saying that. Yes, that's because of the
language in the partial final judgment.
Absolutely, Your Honor. And by the way, that's a stipulated judgment.
That was negotiated and agreed to by the parties.
Absolutely, Your Honor, after reviewing with clients. Now, that's triggering another application of another important rule here, not just the Rubicon of trial rule, but the importance of a stipulation in trial. You know, tons of cases tell us, and bench bar conferences, et cetera, judges want you to stipulate to the issues you're going to go to trial on. Pretrial stipulations are incredibly important, and that's why there's so much case law that says when you stipulate to something pretrial like that, we're going to enforce it, and we're going to enforce it strictly. And the one that's at issue here is even more unique than just a generic pretrial stipulation, because we said, Your Honor, Judge Sleet, as you pointed out, we said, look, here's the judgment if you win, and here's the judgment if we win. And the judgment, if ReadyCap were to win, had everything in it. You're live. The whole enchilada, Your Honor. And that's exactly what our judgment was as well. The whole enchilada both ways.
So if your opponent's trying to say that that's confined to the first trial.
The best response to that, Your Honor, is the plural claims. The plural claims. There's no explanation for why that judgment would use the word claims, plural, when there was one count pending against Dr. Daniels in that case. It's because clearly the only way to read it, and this court has to apply the plain language strictly, the only way to read it is it meant any and all claims. That's what whatsoever means as well. This is not just claims, that's the textual clue here, but no amount whatsoever means at all, you know, no matter what, whatsoever. It also said $0. I mean, there are plenty of textual clues in that stipulation that tell us not just that it was on the merits in the first case, but that it barred the claims that may be brought against her in the future. And that's really what
Go ahead without day language.
it's got to go, and it's got the whole enchilada. Again, it's got every marker you could conceivably imagine. It was arrived to after negotiation, after client review. Everybody knew what the stakes were in this trial, and everybody agreed to them. And that is an independent reason, apart from res judicata, why this court has to reverse and enter a judgment for Dr. Daniels here. It's about enforcing a pretrial stipulation. If this court were to affirm what ReadyCap's strategy was here and the trial court's ruling, why would anybody ever enter into a pretrial stipulation again? You risk waiving important defenses like res judicata. By the way, Your Honors, nothing in the pretrial stipulation says, you know, we'll agree that you can sue us again later. And I want to point that out because the trial court really struggled, frankly, with every aspect of this case. And
if we follow your train of thought, then Ms. Daniels, even though she signed the guarantee, will be off the hook for the guarantee.
the trial court struggled with that issue. And I think
Seems like a legitimate struggle.
it would fall under the public policy exception or the manifest injustice exception to res judicata. But that exception doesn't apply in this case, and the trial court erred in applying it for a few reasons. Now, one, I think when you read the transcript, the trial court didn't say, I'm concerned that this person is, you know, owed money and is not paying it.
The transcript repeatedly said that she felt like she didn't know what was going on in front of her.
Absolutely, Your Honor. And so where I'm going with this is the trial court couldn't have applied that manifest injustice prong here properly because the trial court wasn't following the law. And on top of that, I think the transcript reflects that the trial court actually said it wouldn't be just because it's a different period of default, meaning the trial court was just applying the same legal error on that, you know, fourth or fifth prong, whichever it is, of res judicata, which is the manifest injustice exception. Now, that's one reason. But the second reason is this court's Hardcastle decision already addresses the public policies in play here. And it says, no, when you go to trial, we don't allow you to pull defendants through multiple trials here. That's the public policy that's being triggered here. So if this court were to believe that an exception lies in this case, I think that would be in conflict with what happened in Hardcastle. Because remember, Hardcastle's not even a second case that comes along. Hardcastle was that first case. And this court telling the court in that first case, you've got to enter you've got to enter a judgment on the merits. You can't just dismiss without prejudice. Now, I do want to point out as well, in that first case, the trial court, the transcript reflects that the trial court basically had sort of considered, maybe I do need to dismiss without prejudice. And that's the significance of the party stipulation. No, 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 Your Honor. This is part of our pretrial stipulation. It's not an option for you to dismiss without prejudice. Now, under the law, it wasn't an option regardless. But I'm just raising this because it's significant, because that's another aspect of the pretrial stipulation. The manifest injustice exception can't apply in this case because of that stipulation. That's the third reason that manifest injustice can't be a basis to excuse ReadyCap's trial strategy. And I just want to talk briefly again about the Schmidt case. That's 2021 from this court. It's about as close as I've ever seen with what's going on here. The plaintiff in that case tried to sue under what they thought was a guarantee. They got a judgment, an adverse judgment in that case. Didn't raise the right appellate argument. It's actually not clear on the face of the decision what the defect really was, but it was resolved on an involuntary dismissal. This court said that's an adjudication on the merits. The person tries again a few years later, same plaintiff. This time the plaintiff is saying, look at the money judgment I got in my first case. That is the basis of the debt I'm now seeking in this case. This court's reversed. Said, and the trial court, by the way, in the Schmidt case, bought that argument and said, oh yeah, we didn't really litigate your liability in that first trial, did we? Let's do it this time. And this court reversed that. That's exactly what happened here, Your Honor. Schmidt's frankly just as controlling as Hardcastle on these issues. Now, I just want to walk through a few more reasons that the Singleton exception cannot apply here, okay? First and foremost, it's just limited by its plain language to mortgage foreclosure actions, okay? It could not be clearer. There's not a single case that either party has cited that takes that foreclosure exception and applies it anywhere outside of the law of foreclosure. So if this court were to do that, that would be the first case in Florida to do that. And strongly recommend this court does not do that. Now, another reason Singleton can't apply is because it's about equity. It's a claim falling on the equity side of the court. That's not what this claim is. This is a breach of contract claim. This is a legal claim for money damages. The third reason, Singleton is an installment contract case. There were continuing obligations. And I think we all know the language that they always put in these foreclosure complaints. You defaulted on this date and every installment thereafter. Well, that language was in the complaint, both complaints in this case. And you know what it said? The exact same thing. Why? Because it was the borrower's default. It's what Judge Sleet just pointed out in the beginning here. The relevant default for purposes of Singleton is a borrower on a mortgage. That default was the exact same in both cases, triggering res judicata. On top of that, Singleton talks about decelerating the mortgage. That didn't happen here. This was the opposite. This was a case where the mortgage was accelerated, a judgment was entered on that accelerated amount. That's final, that's binding, that's conclusive. So for every reason that Singleton may not preclude res judicata in the foreclosure context, it does support res judicata in this context. Again, Singleton is an anomaly in the law of res judicata. And on the face of its decision, it recognizes that. Every other case that follows Singleton has no application to what's going on here. That's, for example, like the Bullock case. And I will absolutely admit that the Singleton exception, it applies, in the Rubicon of trial here. There are cases where folks have gone to trial and they've relied on that Singleton exception to get around res judicata. That's why that exception cannot apply in this case, though, because it's not a mortgage claim, it's not an installment contract, it's not an equitable claim, and the party stipulation conclusively resolves that issue. If there are no further questions, I would like to reserve the rest of my time for rebuttal, if I may.
5 minutes.
Thank you.
Good morning.
Good morning. Good morning. May it please the court, my name is Dan Miller. I represent the appellee in this case, ReadyCap Lending. As the court has seen, this is really a res judicata case. There's some other issues that come into play that have been raised by the appellant, but really the focus here is on res judicata. And on its face, at a very surface level, this is the kind of case that you would look at and think, wow, this is res judicata. There's, the lender sues the guarantor, based on an underlying default under these loan documents, loses based on a failure to satisfy a condition
Well,
proceeding.
let me kind of lay the ground for what we're
Yes, sir.
talking about, okay? You keep arguing that, but the stipulation said we're arguing condition precedent, standing, and damages, okay? During trial, you persisted in saying that the complaint in and of itself was sufficient notice. Also, that there was a waiver of the condition precedent. You persisted. You never argued about accrual, non-accrual, anything like that. So, all those were on the table. The fact that you lost, or you won whatever, or you lost your condition precedent the first time, all those others were at play because you decided to go to trial. Why do you get a second bite at all those issues again, simply because you sent a letter to Dr. Daniels after you have a final judgment against the borrowers, and there is it's impossible to have any subsequent defaults, period. So Singleton doesn't apply. Don't waste your time, okay? Tell me.
Thank you, Your Honor. Yeah, the reason is because of the language that the trial court focused on in the guarantee. The lawsuit that was filed originally, the first suit against the borrowers and Dr. Daniels as the guarantor, the claim against Dr. Daniels was based on the fact that the borrowers had defaulted. And ReadyCap's position was that automatically triggered the payment obligation under the
I
guarantee.
know, so you fully litigated it, you had a full and fair opportunity to plead it and argue it all the way to a final judgment, correct?
Yes, Your Honor.
So what entitles you to do it again?
We're not doing it again. It
Yes,
didn't
you
happen
are.
again. Your Honor, respectfully, what happened was Ready.
Her guarantee, her liability on the guarantee is triggered when the borrower's default, correct?
That was our position at
Do you
trial.
agree with that?
Your Honor, I agree with that, but the trial court did not. The trial court said it's only triggered if a demand is
The
made.
law says that, correct?
I'm sorry?
The law says that. The guarantor is obligated when there's a borrower's default.
I believe it
And
does.
you need to notify, in this particular case, you needed to notify her, and you didn't. But you go and pursue the case against her and the borrower. You win against the borrower, but you don't win against her. Why do you get a second bite?
Your Honor, if I could go back to the way that Your Honor is characterizing the basis of the payment obligation against Dr. Daniels under the guarantee. It was our position, obviously, in the first case that it was triggered automatically by the borrower's default. And so there was no need to give notice. In fact, there's language in the guarantee itself that says the guarantor waives any requirement of notice.
Okay,
But
if
the-
you would have won on that issue in the first case, you'd have a final judgment against Daniels and the borrowers, correct?
Yes,
For
sir.
any and all damages in your prayer, correct?
Yes.
Okay, so what about Giuliano from the Florida Supreme Court that says, if it's before a court of competent jurisdiction, same party, same cause of action, it's conclusive as to every matter which was offered and proceeds to sustain and defeat the claim, but as to every other matter which might with propriety have been litigated and determined in the action. So, if you'd have won on the condition precedent, you would have had a final judgment against the doctor and the borrowers. You took that risk, but you didn't. You lost on this one issue. What case, what's your best case that gives you a second bite?
The best cases, Judge, are the ones that talk about where res judicata has to be based on the same claim. This is not the same claim. This is the claim that we won on in the second trial didn't exist at the time of the first action. There was no payment obligation under this guarantee until that formal demand for payment was made.
You argued below that it did exist and you lost.
That's correct, Judge.
You lost.
We were arguing that a claim existed. We lost. The court determined there was no claim.
So you want to argue that it exists now simply because you sent a letter?
Not, Your Honor, I would take issue with that. It's not simply because we sent a letter. I wouldn't characterize it like that. We
Well, what else
performed,
is it? What triggers it?
we performed what needed to be done to trigger that, as was determined by the
Well,
trial.
Hardcastle wasn't given that opportunity.
Hardcastle is different because the Hardcastle, the incident that led to the claim in Hardcastle occurred. That was the arrest.
So did this default occur?
No, the borrower's default occurred. The demand for payment did not occur. The demand for payment is what triggers the action against the guarantor. That was the trial in the first case. The issue about standing and the damages.
The final judgment says nothing about Daniel's winnings on the issue of condition precedent, period. It says you didn't prove your burden of proof and you're going henceforth without delay on all of your claims, all of them. We can't rewrite that judgment.
No, it can't be rewritten. We're not asking that it be rewritten. There's a couple of things there. First, when it says go hence without day, language like that, the standard judgment language in Bullock, it says that applies to the claims that were at issue in that particular action. In our situation, this claim against the guarantor didn't exist because the demand hadn't been made. And what I wanted to talk about, or what I was trying to get to with Your Honor's questioning before, it's not just that we sent out a demand and, okay, now we're trying to do it again. The trial court said that there was no claim. That's what was discussed in the second trial, in the second case, that there was no claim at the time of the first trial because the trigger event hadn't occurred. Whether or not the borrower defaulted really is irrelevant for purposes of the guarantee, because the guarantee states very clearly that guarantor must pay all amounts due under the note when lender makes written demand upon guarantor.
So basically you're saying that the first judgment is just basically a deck action?
It may be that that's how it turned out based on what happened. We weren't.
Deck action that you would have won on the merits and you would have recovered everything if you had won.
I'm not sure how to characterize it in response to a question like that. I appreciate Your Honor's concern. All I can say is that obviously at the time of the first action, we were proceeding under the assumption that the borrower's default was sufficient to trigger the payment obligations into the guarantee. Turns out at trial, and that was really the only issue that was litigated. Everything else was stipulated to. There was no litigation of these other issues, but they were all resolved by stipulation. So the only thing was this issue of whether or not this pre-suit demand for payment was required. So because that demand wasn't made, the claim never accrued. And that's why this isn't a res judicata situation.
Because that's what the judgment reflects. The judgment reflects our global finding, uses language such as Freddie Kaplan failed to meet his burden of proof relative to the breach of guarantee claim.
Yes,
So having recovered no amount whatsoever, not in this trial or not addressing what may happen in the future. He said this is a final judgment based on a trial on the merits. It's the way it reads.
that's the way the judgment reads, Your Honor. If you read, and I know the court's read the transcripts from the trial proceedings, it's very clear what the judge was focused on there and what the basis for her ruling was. In fact, this is one of those cases where the same judge, heard the second case and she had the opportunity to discuss it again, and she confirmed this is what happened in the first case. This was the basis for my ruling. It's very clear that she did that because this demand, which is referenced in the third sentence of the guarantee, this demand for payment, wasn't made. We thought it didn't need to be made. We thought it was an automatic default based on the payment default by the borrowers. We found out at trial that the court did not agree with us and held it under the law because of the way the guarantee was written, that there was no default unless this formal demand for payment was made. It doesn't say it has anything to do excuse me, with a borrower's default. In fact, the way it reads, theoretically, ReadyCap could have just made a demand on the guarantor at any time and said, hey,
That's
even...
kind of like a plaintiff in a motor vehicle accident going to trial and they prepared their experts, they got the orthopedist, the neurologist, all testified. Yes, she's injured, but there's no testimony on permanency. Defendant wins. You want to come back, retry it, have the expert testify on permanency because you lost in the first trial. What's the difference?
Well, Your Honor, first you're getting me way out of my comfort
No,
zone instead of
there's a
litigation.
case
But
on point that talks about res judicata.
Yes.
If you didn't prove permanency, you can't refile, get your experts on board to say that it's a permanent injury. You don't get a second bite.
respectfully,
You
Judge,
didn't prove your case in the first trial. You fully and fairly tried the case, argued to them that it was waived, that your complaint puts her on notice. You persisted Even in spite of the court saying that it's unambiguous, you have to do that. And in spite of Mr. Prodigal saying, Judge, it's not a dismissal, it's a judgment. You didn't object then.
No, Your Honor, what Your Honor is saying is correct. Those arguments were presented during the first trial. And the judge's ruling was that the demand was required. Without the demand...
Isn't that the same thing that you didn't prove it?
No, I would say it's not. What it says is that under the claims we were making, that the guarantee, the payment obligation under the guarantee kicks in as a result of the borrower's default. That wasn't appropriate. That wasn't the proper claim. There was no claim. The judge said there is no claim unless and until you make the demand that's required by the guarantee. We didn't make that demand. We argued and we presented the claim to the court based on the borrower's default. Now we're making a claim based on the guarantor's default, Dr. Daniels' default, her failure to pay in response to a demand. It's a separate claim. It's a claim that didn't exist at the time of the first trial because the demand hadn't been made. All right. There are a few other issues that have been raised here. I would like to point out in the Bullock case, I may have mentioned it already, as far as the stipulation is concerned, language like go forth without day and things like that. Bullock says that those claims are limited, or that language is limited to the claims of that particular case. And there is one of the cases, and forgive me, Your Honors, I don't remember which one, but it does talk about how the court, you can look at the transcript, you can see what reasoning or what rationale has been articulated by the trial court in reaching its particular ruling. So in this particular case, the judgment from the first trial does say that ReadyCap failed to meet its burden of proof or satisfy its burden of proof. But the trial court was very clear in articulating why that was, and it was all based solely on this one particular reason, this failure to make this formal demand. So it's our position that you've got two separate claims here, which is why res judicata doesn't apply. It's also our position as far as whether or not it's a final judgment on the merits, that because it's based on this issue of a demand having been made, it's a technical requirement of the guarantee itself. It has nothing to do with the substance of the defaults. So it would be a technical judgment, so it wouldn't suffice or wouldn't serve as a formal final judgment on the merits. As far as the merger and the deficiency issues are concerned, if there's no questions from the court, we'll rest on our briefs on that. And then finally, just in closing, I appreciate the questions from the court. We see how this does appear on its face to be very straightforward res judicata claim, but it's when you have to peel the onion apart, see what's under that first layer, that second layer, we're talking about two completely separate claims. Without that formal demand, as found by the judge in the first case, without that formal demand, there is no cause of action. So the cause of action that was sued on in the second case simply hadn't accrued. So to wrap it up, the appellant says repeatedly, and this came up in both cases as well, the choices have consequences. ReadyCap made choices in the first case. It led to a negative result. ReadyCap accepted those, didn't challenge the judgment, didn't ask for a rehearing, didn't appeal. In fact, paid Dr. Daniels attorney's fees in that case, and then came back and followed the proper procedures, sent out the formal demand to trigger the payment obligations, and then prevailed. So the choices do have consequences. ReadyCap accepted the consequences of its choices. Now Dr. Daniels has to finally accept the consequences of her choice, which was to guarantee this loan of taxpayer-funded money for the Small Business Administration loan. Thank you.
Thank you, Mr. Bill.
Thank you, Your Honor. Nothing in the guarantee says that the defense of res judicata is waived. There's a section of the guarantee that specifies defenses that are being waived. Res judicata is not listed there. So the face of the guarantee doesn't authorize what happened in this case.
Res judicata was raised as an affirmative defense in the second trial.
Correct, Your Honor. And yes, it was. Yes, Your Honor. Yep. And it was litigated on summary judgment and then raised again at trial in an abundance of caution. The notion that this is not the same claim, again, this court's already got a case, the Shuck case, that says if you go to trial on a premature claim, res judicata is triggered. Shuck cites to the Hardcastle rule. The Hardcastle rule applies. Again, ReadyCap chose to litigate whatever it wanted. The parties all did. That's the significance of a pretrial stipulation. Before that stipulation, you know, the world is your oyster, right? I mean, whatever your affirmative defenses are, whatever's in the pleadings, that's the point of the parties coming together and entering into a pretrial stip. This court needs to protect the parties' right to enter into a pretrial stipulation. I also want to direct the court, look at ReadyCap's demand letter. It's at page 31 of the record. It's asking for all amounts due under the note, which has since merged into the partial final judgment. It's identifying the exact same borrower's default that was accelerated and that resulted in a judgment affirming that acceleration. Okay, so the demand letter tells us it's the same exact claim and it's exactly what happened in the Schmidt case. That's what the demand letter tells us. I'm coming after you for that judgment I got in the first action, but I didn't get all the way against you. I didn't hear any argument about the Schmidt case distinguishing it. I don't think there is any argument to distinguish it. Again, the stipulation can't be rewritten, Your Honor. It was effectively a settlement of the claims. It was sort of a contingent settlement. I mean, that's how I've viewed it. This court can't make the parties settle on terms that they didn't agree to. So it can't rewrite the stip. There's no explanation for why the word claims was used in the plural. Judge Black, you've already identified there's a ton of markers in that stipulation that show it was final, it was on the merits, and it precludes further claims. The notion that you can go to the transcript doesn't mean you can rewrite the party's stipulation, and you can't. Now, if ReadyCap wanted to seek relief from the stipulation, it had to do that in the first case, it had to appeal. It's never tried to relieve itself from the stipulation. Stipulation remains binding. If there are no further questions, Your Honor, I'll rest on the briefing.
Thank you.
Thank you.
Thank you both. Well argued. Have a nice day. All right, the next case is Barbara Feliciano. Feliciano.